It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt, on the radio, on podcasts, on Facebook, on YouTube, and on talklawradio.com. Today I'm going to be talking about a court case that proves the point that sometimes your secret intentions may not be legally enforceable. Remember to tune in on Saturday mornings to Talk Law Radio. I'm on 9:30 a.m. The Answer. Also, Facebook Live. You can learn about some area of the law that I think needs to be explained. Usually I have a guest to help me explain that. I like to tap experts in the San Antonio, Texas area to talk about business law, estate planning law, probate law, guardianship law, and business law. Marquardt Law Firm sponsors our show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. Also, old businesses and new businesses, which might have issues with corporations, contracts, LLCs, family-limited partnerships, and we can help those who are facing problems from lack of planning, like in county court, district court, or probate court. Without further ado, I'll start talking about the law. So, I want to tell you a story. I want to share a case with you, a real live case, with real live people with this problem who had a goal in mind or several goals in mind that were good goals to have for a family, but because they thought that they could do everything themselves just with their own understanding without having anything in writing, several problems developed. So this is the case of Ayers versus Mitchell. The characters in this case were Roy, the father, Lorraine, the mother, Gail, the daughter, and Larry, the son. Some lesser-known characters that will be featured are Marcia, the daughter, and Paul, the son. So what happened is Roy and his wife, Lorraine, wanted to get qualified for Medicaid someday, and they wanted to protect their assets from their other children misusing their assets. So Roy and Lorraine deposited funds in an account at a bank with two of the children, Gail and Larry, who were signatories to the account. And Roy and Lorraine were up in age, and they were worried about medical care expenses, and they trusted their two children, Gail and Larry. Gail testified later that her parents asked her to take charge of their life savings to provide for their future health care needs. She said her parents wanted her to shelter these funds from Medicaid. So I guess the life savings was $48,000. And this is, I think this court case happened in 2004. Even in 2004, $48,000 was not a very large life savings. I'm not sure how they financed all these court battles over $48,000, but we'll talk about it. Gail's Social Security number was shown on the account, and she paid the income taxes based on the interest that account generated. Okay, so Lorraine died sometime after creating that savings account, and in January 2003, Roy had surgery to amputate one of his legs. Following his surgery, Gail and the other daughter, Marcia, suggested that Roy go live in a nursing home. Larry, the son, was opposed to this idea and took Roy to his home to live with him. Larry testified that he gutted his home and did significant remodeling to make the home accessible for Roy. There's testimony that Larry isolated Roy from the rest of the family. Larry, a single person, hired care providers to come into the house to help with Roy's needs and with the cooking and other household chores. One caregiver testified that it was her understanding from the other caregivers that Roy was not to be left alone with other members of the family. Larry's son, Jeff, testified that Larry told him not to associate with Gail or the other daughter or any of their children. Jeff also testified that Larry had coached Roy on how to answer questions in court. In June, Gail became aware that Larry had been writing checks of increasing value out of Roy's checking account. This was a different account, not the savings account that I first talked about. So Gail moved the funds from that checking account and opened a new account with herself and the other daughter as signatories, but the other daughter removed herself from that account, so it was only Gail. Gail testified she viewed herself as trustee of these funds and felt responsible to protect the money and see to it that the money was used for Roy's reasonable medical needs and for his comfortable living expenses. So Gail had sole control over the funds in the savings account, and Roy testified that he demanded those funds back. When Gail refused, Roy filed a lawsuit against her, probably with Larry's help. That's my own opinion, alleging, among other things, breach of contract, conversion, breach of fiduciary duty, and fraud. Roy also sued for a declaratory judgment that all monies in issue are owned by himself and should be returned to himself. Gail counterclaimed, seeking a declaratory judgment as to the existence of a trust, terms of the trust, and as status as trustee, and deposited those funds into the registry of the court. So let me pause there just to comment on this situation. There was never any testimony that an actual trust document was written or signed. Gail testified that she viewed herself as trustee, right? So there was no trust document. And so that's what this case is about, is whether an oral agreement or an oral understanding can be a trust. Well, the district court in Wood County, Texas, rendered judgment that Roy take nothing, that the funds at issue were held in an irrevocable trust for the benefit of Roy, and Gail was the sole trustee of that trust. So isn't that interesting that the court found those facts? Let me find some other facts that the court said were true. The court found, among other things, that the bank in question did not reflect that Michelle was trustee. But isn't it interesting that the court found that a trust existed, even though Gail was not listed as trustee on the account paperwork? They found that Roy and Lorraine intended that Gail hold the account subject to their requirements for comfortable living and medical needs. The court found that Roy, Lorraine, Gail, and Larry were permitted to withdraw from the account. So remember that. Roy and Lorraine were also able to withdraw funds from that account. This is an important fact that comes into account with the Court of Appeals opinion. Right now, I'm just telling you what the lower court held. The lower court held that Lori exerted undue influence over Roy, that the only withdrawal from the account made by Gail was for the construction of a bridge requested by Roy. So that's an important fact also, that Roy asked his daughter to pay for the construction of this bridge, and she did so. So that sort of shows that Roy had some control, and that's an important fact that I'll discuss in just a moment. The lower court held or found that Roy was disoriented on the day of the trial. He was unable to care for himself, and that he needed to have a guardian. The court found that Roy and Lorraine intended to completely divest themselves of any legal interest in the account in question. Remember this point. The court said Roy and Lorraine intended. So this is an important fact as well. The court found that Roy never made a demand on his daughter for the return of the account prior to filing the lawsuit, even though that's what he testified to. The court said that Roy and Lorraine intended for their daughter to have complete control over the account, subject only to their needs for health care and comfortable living. And the court concluded that the daughter was trustee of the funds, and it was intended to be irrevocable. That should any of the trust fund remain after the death of Roy, the trust terminates, and the funds should be paid out equally to the children of Roy and Lorraine. So let me tell you about an oral trust, because that's what this case is all about, is telling us what the law is and whether an oral trust could be created. So the Court of Appeals here, it's a Texas Court of Appeals, it's a state court, but it's reviewing the opinion of the district court, the lower court. In general, a trust must be in writing to be enforceable. That's Texas Property Code section 112.004. Statute requires a trust, neither real or personal property, to be created with a written document. So this is a hidden legal issue blind spot. I've met people that are like this. They have goals in mind, and they create out of thin air ideas about how to accomplish those goals without asking attorneys or accountants or financial services representatives about whether that's the correct way to do it, or whether that will achieve their goals or objectives, or whether it's even a good idea. Let me mention that I can't give you legal advice during this radio program because legal advice must be tailored to the specific circumstances of each case, and laws are ever changing, and so you should call your own attorney, somebody that you like and trust and are comfortable with, and ask them how these laws might apply to your specific facts and circumstances. So this is not legal advice, it's just general information. This case is publicly available for you to read for yourself. I'm just telling you what my opinions are about it. So the trust should be in writing. Well, the Court of Appeals further wanted to define some other things. Beneficiary is a person for whose benefit property is held in trust, regardless of the nature of the interest. That's Texas Property Code section 111.004. Gail, the daughter, never alleged that she was a beneficiary of that trust. The evidence does show that at that time or before the bank account in question was created, Roy made statements to her consistent with creating a trust. But fatal to the daughter's contention that an oral trust was established, the court said that there was no complete transfer of trust property. So this is where I'm coming back to some of those earlier facts that the trial court found. As it pertains to trust, the Texas Property Code does not contain a definition of transfer. However, there are several other court cases that did define transfer, and so I'll go for that. I'll go over that. The principal difference between a trust and a gift lies in the fact that in the case of a gift, the thing given passes to the donee, while in the case of a voluntary trust, only the equitable or beneficial title passes to the trust. So that's the difference between a complete gift and a partial. In each case, the equitable title must pass immediately and unconditionally, and the transfer thereof must be so complete that the donee might maintain an action for the conversion of the property. Absent a completed gift of the equitable title, no trust is created, for an imperfect gift will not be enforced. The deposit of money in a bank under a trust title is considered equivocal. Men frequently deposit money under a trust title from other motives than that of creating a trust. So there's this case, Fleck versus Baldwin, which held that there was insufficient evidence of trust creation, particularly lack of evidence of original owner's intent to yield control over funds in question. So applying these principles applicable to gifts, the Court of Appeals held that to have a transfer of the trust property to a trustee, the transfer must divest the trustor of all dominion and control over the trust property. In this case, there's evidence that at or before the time the funds in question were placed in the savings account, Roy and Lorraine instructed their daughter to take charge of such funds to provide for their future health care needs. Roy's niece, sorry I didn't list her in the cast of characters, Irene, testified that Roy told her that his daughter was in charge of his finances. But there's further evidence that shows that neither Roy nor Lorraine ever divested themselves of all dominion and control over the funds because they remained signatories to the account. They could have withdrawn the money themselves. If a trust document had been written, if it had been signed, if it had said that the money was there for their benefit, but under the control of the daughter, only the daughter would have been able to pay funds from that account. So because Roy and Lorraine remained as signatories on the account, that defeats any claim that the funds in that account were transferred away from them. So even if there had been a trust, it would not have been funded. Roy's continued control over the account is also shown by the daughter's testimony that her father instructed her to deduct $2,425 from the account to reimburse the daughter for the cost of the bridge. Remember, I mentioned that before. Roy's authorization of this expenditure shows his continued control of the funds. So, the court held as a matter of law there was never a transfer of the trust property to a trustee. In the absence of a writing representing the creation of a trust, and in the further absence of complete transfer of the funds, the court held as a matter of law no valid trust was created. I just want to point out that they could have done this. They could have gone to an attorney and said, we want to create a trust. We want these children or this daughter to be the trustee of that trust. They could have said, this is for the purpose of us to qualify for Medicaid someday, or this is for the purpose of making sure that our other children don't misuse our funds. They could have done all of this. They could have saved probably tens of thousands of dollars in legal fees and court costs just by going to an attorney ahead of time and saying, this is what we're thinking. This is what we'd like to do. Is this possible? Can you help us with this? Can you help us make sure that this goes okay? So I wanted to go over some of the general rules because you're probably thinking in your mind about gift taxes, or you're thinking in your mind about the look back and the penalty period for making gifts. Yes, those things are issues in this type of situation. So you need to think about the tax consequences and the government benefit consequences in the future. Usually, there's an advantage and disadvantage for everything that you do, even in your own life right now while you're still healthy and alive. You weigh the costs and benefits, the risks and advantages of doing certain things in your own life. If you make a mistake, you only have yourself to blame. But if you name somebody else as trustee, they have a higher duty of care to make sure that they don't make mistakes. Let's go over some of the rules. In order to qualify for Medicaid to pay the high cost of long-term care, there is an income limit of $2,829 as of 2024. These numbers change all the time, so if you're listening to this and it's not 2024 anymore, probably need to get an update on what that income limit is. If you're married and only one spouse is trying to qualify for nursing home Medicaid, the healthier spouse, the spouse that stays at home in the community, is usually able to save some income and save some assets. And I won't go over that because it's confusing and these numbers are subject to change. But the general rule in order to qualify for nursing home Medicaid is that you have to have less than $2,000 in countable assets. Some assets are not countable, like the homestead. You're allowed to have a home and still qualify for nursing home Medicaid. But after you pass away, the state of Texas is going to want to recover those assets or those funds to be reimbursed for the cost of your care. The only people that lose their homes to Medicaid are people that don't know the rules or don't like lawyers. It's easy to keep your home, avoid estate recovery, as long as you see a lawyer in advance. This is a hidden issue legal blind spot. If you make gifts that are valued over $18,000 per person per year, the IRS says that you should file a 709 gift tax return. Doesn't mean you have to pay tax unless you make lifetime gifts over $13,610,000. That's a 2024 number. And your homestead value should be under $713,000 in order for it to not be countable. If you make gifts for less than fair market value to somebody, there is a look-back period of 60 months. 60 months before you file your Medicaid application. And if you have done that, then there's a transfer penalty that goes forward from the day that you file your Medicaid application. And you calculate the number of days that you're going to be penalized by dividing the value of the gift by the average cost of nursing home in Texas for a month, which in 2024 is $7,339. Well, I've run out of time for today. I've enjoyed presenting this material to you. Please follow us on LinkedIn, Facebook, and YouTube. Subscribe to the YouTube channel. Tell your friends about Talk Law Radio and everything that you've learned. Listen on Saturday mornings and Sunday afternoons. I'm Todd Marquardt. I'll talk to you later.